One common question that we get is, knowing a case is starting in general sessions court, what happens at a preliminary hearing, which would potentially be the last court date in general sessions?
Yeah, so a preliminary hearing, generally there's two purposes that your attorney has at that court date. So first off, it is the only opportunity we have to put either a police officer or a witness, a victim on the stand for the state to be able to prove that they had probable cause to place you under arrest. So the first and primary purpose, most of the time that we have, is to try to get that case dismissed. Prove to the judge that the state did not have probable cause to place our client under arrest by proving that they didn't meet all the elements. For example, they can't prove that our client was impaired if it's a DUI case. If it's a criminal case, such as a domestic assault, prove that the assault did not happen or the person didn't suffer a bodily injury. There's always an issue that we try to prove to get a dismissal. But then there's a second purpose as well, because like I mentioned, it is the only opportunity we have to ask that officer questions under oath. So it's sworn the same way that they would be sworn under oath if they took the stand at a jury trial. So we get to ask that officer questions and potentially get that testimony to use at a later date for purposes of filing a motion in criminal court, to prove that they illegally arrested you, illegally obtained a blood sample. There's a bunch of purposes that we can use at a later date in criminal court.
Absolutely. And obviously, the goal is always going to be to get the case dismissed, but that's not always possible in every case. So, the importance of the opportunity of having a witness sworn in under oath and being able to take that testimony, like you mentioned, does become very important for the progression of the case at the next level, because in criminal court, circuit court, in some jurisdictions, you have the opportunity to file motion to suppress, motions to dismiss. And if you already have witness testimony under oath, then we at least have an idea of what we expect that witness to say, which then turns on that witness's credibility. Because obviously, if they're under oath and they're making statements that are different than what they would at a proceeding or a hearing coming later down the road, then we are able to, one, use that for negotiation purposes in terms of talking with the prosecutor to let them know, hey, your witness has some credibility issues, or we're able to just show the judge that they have credibility issues because their statements have changed.
Yeah, and I think you brought up an important point there as well, is outside of just filing motions, as I discussed, is that we also can use that testimony for negotiation purposes. Because at that point, we know exactly what the state's proof is going to look like at a jury trial. So we can prove to the prosecutor that their case isn't as strong as they thought it was prior to that hearing, break down the testimony and prove to them that this is a case that we need to get resolved favorably for our client.
Yeah, and that goes into one common question, kind of piggybacking off of that, is whether the client, whether the person accused is going to be testifying at a preliminary hearing.
Yeah.
And it's just not likely because, again, obviously we're trying to get the case dismissed, but more importantly, we potentially want to see what the state's evidence looks like. And we don't ever want to give a client or a person accused with the crime the opportunity to be cross-examined by prosecutors of the state until or unless we ever have to do that.
Yeah, absolutely. Because once again, the same way that that officer or that witness or victim would have to swear under oath to everything they're saying, so would our client. And so we don't want to give the state that opportunity prior to a jury trial to then be able to use that testimony against them if they slip up and say something slightly different at trial.